Generally, a successor trustee cannot change or amend a trust. Most trusts are initially managed by their creator or original trustee while they're still alive and competent. But after they pass, a successor trustee must step in to take legal title to assets and administer the trust according to its written terms. Many successor trustees are spouses or adult children of the person who made the trust, and they often find themselves embroiled in familial conflicts about who gets what from the estate and when and how they get it. As trust lawyers, one of the most frequently asked questions we get is whether the successor trustees can change or amend a trust. Let's take a look at that. Can a successor trustee change a trust? Generally, no. Most living or revocable trusts become irrevocable upon the death of the trust maker or makers. This means that the trust cannot be altered in any way once the successor trustee takes over management of it. The successor trustee's primary job is to administer the trust according to the explicit and implied wishes of the original trustee as written in the document. A successor trustee may not modify or add or remove beneficiaries from an irrevocable trust, for example. They must also never give the impression that they have the power to do so, especially to force beneficiaries into signing releases of trustee liability in return for distributions. A successor trustee essentially works for the beneficiaries and has a duty to carry out trust administration in a manner consistent with its stated provisions. Can a successor trustee amend a trust? A successor trustee cannot amend an irrevocable trust themselves, but they can potentially have any amendments made by the original trustee voided if they were the product of undue influence, fraud, coercion, or duress. This can have the effect of reverting the trust back to its previous version and terms. Can a surviving spouse change or amend a trust? Sometimes. Sometimes a trust will give a surviving spouse rights to change a trust after the first spouse dies, but this is relatively uncommon. Similarly, a trust may give a surviving spouse or another heir a general or limited power of appointment. This means that they may be able to remove or replace beneficiaries if the trust expressly allows them to do so, and in the manner the trust dictates. We often handle cases where a step-parent outlives a blood parent as a co-trustee and then tries to disinherit their stepchildren. Depending on the facts of the case and the language of the trust, this may or may not be allowed. Consulting a trust litigation attorney is crucial in learning about your rights and how you might be able to enforce them. Can a successor trustee remove a beneficiary? Generally speaking, no. Successor trustees cannot eliminate a beneficiary, reduce a beneficiary's share, or refuse to make distributions to a beneficiary unless the trust document specifically gives them the discretionary power to do so, or makes a beneficiary's inheritance conditional upon meeting certain requirements, the failure to comply with which give the trustee the authority to disinherit them. Can a successor trustee remove a co-trustee? Most of the time, trust creators name one successor trustee, just to make things simpler and avoid unnecessary disputes. But sometimes the original trustee will name multiple successor trustees who will share that authority and responsibility for administering the trust. When this is the case, a successor trustee can only remove a co-trustee if they've harmed the trust or engaged in misconduct, negligence, or somehow breached their fiduciary duties. Trustee breaches are more common than you might think, however, so a successor trustee with a good case may very well be able to remove another trustee. If the co-trustee is also a beneficiary, they might be relieved of their trustee authority, but it's less likely that they'll be disinherited as a beneficiary. Can a successor trustee take over if the original trustee is still alive? Not unless the original trustee has become mentally incapacitated or voluntarily resigns from their position. Successor trustees don't have any authority, don't have any power over a living irrevocable trust while the original trustee is still alive and well. But sometimes, successor trustees are concerned about the original trustee's continued ability to manage the trust due to aging, declining health, or perhaps neurological problems. This is why so many trusts, or durable powers of attorney, for example, contain provisions for deciding whether the maker is still capable of handling their affairs. Oftentimes the document will appoint a trusted and unbiased party, doesn't have to be a doctor, could be a friend, but most often a doctor, to judge the original trustee's mental fitness or lack thereof. And based on that assessment, a successor trustee may be authorized to take over. Can a successor trustee change beneficiary distributions? Can a successor trustee change beneficiary distributions? Unlikely. Unless a successor trustee is granted specific powers to do so, in writing in the document, they cannot arbitrarily or capriciously increase or decrease a beneficiary's distribution in an irrevocable trust. But successor trustees usually do have broad discretion in terms of what, when, and how they pay beneficiaries. And trusts usually don't have a specific deadline for when this has to be done. This is to give the trustees sufficient time to settle the affairs of the estate, sell securities or property under the most favorable conditions before making those distributions. But we've seen far too often cases where sibling rivalry or family feuds have resulted in trust distributions being withheld out of spite or apathy under the guise of things just taking time. If a successor trustee is not offering a valid, documented, and business-like reason for withholding a distribution, the reality is that the trust beneficiaries might have to take legal action to get what's theirs. What if a successor trustee pressured the original trustee into making changes? If there's sufficient evidence or testimony to suggest that a successor trustee took advantage of an original trustee's weakened or debilitated state to force them into making self-serving amendments to the trust, the other beneficiaries or heirs might be able to sue the successor trustee for undue influence, especially when there's documentation of conditions like Alzheimer's or dementia, or when the original trustee was dependent upon the successor trustee for caregiving services, as long as they're not a family member. A successful claim of undue influence may void any disadvantageous changes or amendments made to the trust that you're having questions about. Have questions? Give us a call, shoot us an email. The consultation is always free. Thanks for watching.